along that process. In 1915, the Supreme Court said that it is unquestionably the right to have one's vote counted is as open to protection by Congress as the right to put it in a ballot box. So Congress has an obligation to ensure not just that people have a right to vote, but a right to have their vote counted. In 1964, the Supreme Court said this directly, saying all qualified voters have a constitutionally protected right to vote and to have their votes counted. Right now, at its core, we have 22 voters who have had their right to have their vote counted denied. And so I'm sure that many of you are going to have a lot of questions about process, but it's important to not lose sight of the fact that the right to put a ballot in a ballot box is not a right to vote unless you have your vote counted. And 22 voters who did everything right now remain without their right to vote because their votes haven't been counted. That is what is at issue in this instance. We have an election that right now the margin between the two candidates is 6 votes. It is among the closest elections in our country's history. And when you set aside all of the procedural issues and niceties about where the case is and where the case is going and what happens next in the contest, you need to not lose sight of the voters. This is fundamentally about them and their rights and who's going to fight to make sure that they didn't go to the trouble in the middle of a pandemic to cast a ballot only to have it not count. So there has been some question that has come up about, whether or not this is the same or different than past election contests. Every election contest begins after a state has certified an election results. And there has never been a serious question as to whether or not an election contest where you've identified specific votes in excess of the margin can proceed forward. Anyone who tells you otherwise doesn't know what they're talking about. If you look at any of the pleadings, for example, which are all available online from 2020 in the states in which Donald Trump brought election contests, you will see what I and other lawyers said was not that there is no right to a contest, but rather that in order for a contest to proceed, they need to plead a specific individual number of votes on an individual voter by voter basis that could overturn the outcome of the election. That has always been the standard for a contest. That will always be the standard for a contest. And that is a standard that in this instance, Rita Hart has met. Because in fact, we have identified 22 individual voters. These are not categories of voters. These are not hypothetical voters. These are not theoretical voters. These are actual people who live in Iowa's 2nd Congressional District, who had their right to vote denied due to problems with the election administration or election judge error. So where are we in terms of the process? We, as you know, filed our notice of contest pursuant to a federal law that told us to file our notice of contest in the US House, okay? So why did we file in the US House? We filed in the US House because in 1969, Congress passed a law, passed the House of Representatives, passed the US Senate, signed by the president, called the Federal Contested Election Act, that said, if you want to contest a House election, file it in the US House under these procedures. So we followed the law, we filed in the US House. The lawyers for Miller-Meeks filed a motion to dismiss that contest. That motion was deferred pending the next steps in the process, which means that the contest will proceed. The The chairwoman of the committee, chairperson of the committee, sent a letter to both sides asking each side to address essentially the practicalities of how this should proceed from here. You know, what are the next steps? Under the statute, we're entitled to begin discovery today. And I think the committee understandably wanted to get a sense for kind of how each side sees this process playing out. We laid out a very, very streamlined process that we think can get to the heart of this. We propose that we allow voters to submit affidavits to minimize the time and expense that they and the parties go through. We propose that this entire matter could be resolved by early July, so that by then the people of the 2nd Congressional District will know who got the most lawful votes. Now, that may seem like a fast process, but actually, by historical standards, that's a relatively lengthy process for an election contest. So it gives everyone lots of opportunities, both sides lots of opportunities to put forward whatever arguments they want to make and whatever individualized votes they want to offer that should be counted. What the other side filed yesterday was 2 documents. The first was their own procedure, which largely consisted of them saying that they are upset that there is a process. They didn't so much as offer a suggested route forward as held their breath and said they're not in favor of the process. Well, federal law sets out that there is a way to bring a contest in the House, and that is what the House is following. The other document that they filed, which I think might be overlooked and shouldn't be by any of you who are covering this closely, is their answer. So we had filed our notice of contest. They had filed the motion to dismiss. They had to file an answer. They filed their answer. What is and is not in their answer? Well, what is in their answer is a continued assertion that the U.S. House of Representatives should not follow the law that Congress passed in 1969. Okay, so we know that. They've been clear about that. They don't believe that Congress should hear an election contest, notwithstanding the fact that Congress has been hearing election contests since the beginning of the Republic, notwithstanding the fact that in 1969 Congress actually passed a law saying that the House is the proper forum for an election contest in the House. We understand that's their position. What didn't they say, though? And this is where I think it's really interesting. I was expecting to see in their answer one of 2 things or both. Number one, well, you say there are 22 votes that weren't counted. Here are other votes that were counted. Right, that would have been one thing you could have seen. They could have said, well, you identified some votes, but we've identified other votes. Very telling they didn't do that. Very telling they didn't do that. And that's because, as I think Riley has made the point to you before, we identified a category of votes, not all of whom likely voted for Rita Hart. We actually went out and identified the votes of people whose ballots should be counted. And so it's very telling that they didn't, you might think they'd come forward and say, oh, yeah, but you cherry picked, right? The fact is we didn't cherry pick. We included both likely Hart votes and likely Miller-Meek votes. So they didn't do that. The second thing you might think that they would have done if they could, because after all, they've had a long time to look at this, right? I mean, this is not sprung upon them, right? This election's been very close now for several months. They didn't offer any evidence why the 22 votes shouldn't count. Think about that. They didn't say, oh, you identified this voter, but let me tell you why that vote was correctly rejected. Right? They made some conclusory allegations that basically they deny our complaint, but they don't offer any evidence that we're actually wrong about any of the 22 votes. They don't say, well, here's an affidavit that says, no, 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 you got it all wrong. This was actually what happened. So it's very interesting. They don't suggest that there are other votes out there. They don't identify any. And they don't suggest that the 22 voters, they don't offer any evidence that those 22 votes shouldn't count. So where does that leave us? We are asking for a fair and even review of the process. Miller-Meeks didn't say that those 22 votes shouldn't count, or offer evidence rather that they shouldn't count. They offered procedural arguments, but they didn't offer evidence as to why they shouldn't count. In part because she's already said publicly, probably before lawyers got this kind of in a box for her, right? She already said that there were lawful votes that didn't count. So we want a fair, transparent process that follows the facts and ensures all lawful votes are counted as reasonably expeditiously as possible. We've set out a timeline and a framework to do that. We hope that the committee adopts that framework, but we'll be prepared whatever happens. We are prepared to move forward with discovery in a very collaborative way, with minimizing the burdens to the voters and to the committee, or we're prepared to move through the more formal process. You may at some point see a miscellaneous action opened in the Iowa state court system. That is not a new lawsuit. That's not doesn't mean there's a new legal action. It's just a mechanism by which in a federal contested election act case, discovery is effectuated. So no one should react if they see that opening on the docket. That's just a procedural add-on to the House, because obviously subpoenas and other document requests get done through the local court system, not directly from the House. But we're trying to minimize the burden. We're trying to make this move smoothly and quickly, because the people of Iowa too deserve to know who received the majority of lawful ballots cast in their election. So with that, I will take any questions.
Great, thanks so much, Mark. So before I open it up for questions, if you have a question, go ahead and raise your hand using that particular function through Zoom. When I call on you, if you could just state your name and the outlet that you're with for Mark, that would be helpful. So,
and am I going to be able to see them or no?
On video.
Or else they should just, as you say who they are and what outlet. Yeah, that's fine.
It'll be audio. So I want to go to Kate Payne first. Kate, you should be able to speak now.
Okay, great. This is Kate Payne with Iowa Public Radio. So more moderate Democrats raise concerns about this process, about ultimately having to take this vote, while Republican groups are targeting vulnerable members. So is this fight really worth all of that?
So first of all, my rule in all election matters and all litigation is to just take things one step at a time. Right now, our goal is to make sure that every ballot cast that should be counted is counted. We're in the process of making sure that evidence is produced to the committee so the committee can rule on it. I believe firmly that if it turns out that there are lawful ballots that were not counted that should be counted, they will be. And I believe that all members of Congress, Democrats and Republicans, will want to make sure that the will of the people is followed. At its bottom, this is about the voters, and I'm confident that if those 22 votes are counted and they yield the results that Rita Hart received more lawful votes, that the process will take care of itself.
Great, thanks, Kate. Go now to Jonathan Ketz. Jonathan, you should be able to speak.
Hey, Mark. I work for Red WQAD out of the Quad Cities. I am curious where the written proof is, the written documentation from the state level. Obviously, I know that you filed this contest to the House of Representatives, but where's the written documentation, maybe from the Secretary of State's office, that confirms your guys' claims of these 22 ballots not being counted, that would put Rita Hart in the lead by 6 and have her actually becoming the Congresswoman for Iowa too?
So a couple of things. The first is that, we have put forward the 22 votes and we're asking the House to judge, as is their role under the Federal Contested Election Act. We are asking them to open and count those votes. We believe, based on when those are counted, that Rita Hart will have received the most lawful votes. But the process here is not before the Iowa Secretary of State. The process here is before the House, because that is, in fact, the process that federal law sets forth.
When you guys did your investigation with all the different county auditors, did it have to go through the state level at all to find these 22 votes, or did you just talk to individual county auditors at that level?
This was at the county level.
Great, thanks, Jonathan. I want to go to Nick Fandos with the New York Times. Nick, you should be unmuted.
All right, can you hear me?
Okay. Yes, we can.
Hey, thanks, Mark. I was hoping I'd get your response to two points or criticisms raised by Republicans. The first not being a legal issue, but basically insinuation that you all went jury shopping and skipped over the Iowa State court process because Democrats are in control of the House and may give you an outcome you like. So I was wondering if you could just answer, why Rita did not make any appeal in the state courts during that brief window back in November, December. Secondly, I was wondering if you could just address the criticism that they've raised, or the conflict of interest concern, given that you, I think personally, in your firm represent several members of the House Administration Committee who are going to be conducting this review in addition to Ms. Hart. Thanks.
Sure. There's a part of me that laughs at the first, actually, it's a lot of me that laughs at both of them. but on the first, I think I was accused in other contexts of going to state courts rather than federal courts by the Republicans in Pennsylvania, North Carolina, and elsewhere in November of 2020. So what I've learned about Republicans is they're going to complain anytime you go anywhere to try to get votes counted. If we go one place, they complain. If we go another place, they complain, and that's an unfortunate commentary on kind of where they are more generally on voting. We went to the House because that's what federal law provides for us to do. We didn't go to the Iowa court system because given the impossibly short review period permitted by the Iowa court system in unusual cases like this one, we thought that the Federal Contested Act's guidelines allowing for a full recount were more appropriate. There wasn't a way to effectuate that in time in Iowa. So it had to do largely with that. But again, I have not yet found an instance where the Republicans have thought that any voting rights should be protected in any form. With respect to the second, it's nonsense. I mean, the fact is that I don't represent the House Administration Committee on this matter. I represent Rita Hart. I think everyone knows that. I think the fact that I have represented Democrats in the past is not a secret. I think all of you probably have known that. I think the Republicans know that. There's not some, there's not some secret. There's not some secret going on there. But I'm handling this like I handle any other matter before the House or the Senate, which I've handled before, or for that matter, that I handle in court. We're going to make the best case we can for these 22 voters, and hope that they count.
Great, thanks, Nick. I want to go now to Alan Fram with the AP. Alan, you should be able to unmute.
Hi, can you hear me?
Yes, we can.
Great. I'm wondering if there are enough Democrats opposed to unseating Miller-Meeks that a House vote on that would fail, which seems entirely possible. Would Hart be willing to abandon her challenge?
I think we're like way down the road here from where we are right now. Right now, we are in the process of ensuring we're in the midst of ensuring a fair process that these votes are counted. Let's wait and see whether those votes are counted, whether there's a full recount, and what the results are. I am always of the opinion that if the results show that more lawful votes were cast for one candidate than the other, Democrats and Republicans alike, are going to be fair-minded about it and are going to want to make sure that the will of the voters is followed.
So you're not ruling it out?
I haven't even contemplated. It's so far down the road. It's not even something that I have contemplated. I mean, and honestly, Riley, I'll kick it to you. I'm not even sure it's in the ambit of something I could even address.
Yeah, I mean, I think right now we're focused on making sure that every Iowan who cast a legal vote has their ballot counted. We're going to let the committee work through this process and follow the facts. So, yeah. Like you said, down the line. Next, I want to go to Tom Barton with the Quad City Times. Tom, you should be unmuted or have the ability to unmute.
Hi, thanks. Can you hear me?
Yes, we can.
All right, Tom Barton with the Quad City Times. I just had a question on the procedure that you're outlining. So the procedure, would that include a recount then by the GEO, or excuse me, the GAO, or are you focused just on getting those 22 ballots counted in this latest response?
It's both. We've identified the 22 votes that we can identify on a voter by voter basis, which I think is jurisdictional in a contest. That's a point that I think the statute makes. It's a point I tried to make in my opening remarks. It's a point that, if you want to go look at the positions I've taken or that, others have taken in other contests, that's kind of the first step. We also think that that there would be a benefit to the fairness of the process and to the completeness of the process for there to be a full district-wide uniform recount, so that everyone's vote is treated alike, and that we make sure that the process worked exactly as it should.
Thank you, Tom. And then I want to go to Ali Mutnick with Politico. Ali, you should be unmuted.
Great, thanks. So I've got a question about the FCEA that you may or may not be able to answer. I'm wondering if the administration committee comes up with a report, does an investigation, says Rita Hart should hold the seat. Is there a requirement in the FCAA that has to translate into a floor vote, or is it possible that it can kind of just lag in the committee if no one schedules it?
Yeah, you've now stumped the man. I don't think that's an FCEA question, which I would actually be, I think, okay to answer. I think that's actually like a House procedure or House rules question, which I don't know.
Okay.
Sorry, Ali.
That's okay.
You have
Thanks.
another one? Because I feel like I totally failed you.
No, that was my main question.
I don't know. You'd have to ask someone who's an expert. Truth be told, I've never actually worked in the U.S. House or the U.S. Senate. So when you guys get into the innards of like how bills move from committee or how resolutions or other things move from, internally, I'm not your best guide.
They just don't make themselves as available for questions as you do, so I had to try.
Thanks, Allie. And then last question here is from Laura Olson. Oh, she just put her hand down. Laura, if you, there we go.
I feel like you just made Laura Olson ask the question.
That's all right. Thank you for doing the call. I think this follows up on a couple of things that were asked, but to ask a little more broadly, do you see a way that this reaches a conclusion that will be accepted? Because this has become such a polarizing dispute where it seems like we're going to, one way or another, come into a conclusion that half of the folks are going to think was unfair. So can you talk a little bit about how we go forward in a way to hopefully make this something that will make it feel like everyone's vote had been counted in the end here?
Yeah. So Laura, what outlet are you with? I'm sorry.
I'm with the Iowa Capitol Dispatch.
Great. I think that's like a really important question. I really do. And it's something I've reflected a lot on, not specifically about this contest, but we had a circumstance in which 140 members of the House voted against certifying election results at the presidential level that were indisputably accurate. I think probably all of your news outlets have reported that those results were accurate, but nevertheless, we saw, a sizable number of Republicans vote to not accept those results or to challenge the results. We saw, 127, I think, House Republicans sign onto a brief filed by the state of Texas to disenfranchise four entire states. And of course, you and I are no stranger to the recent wave of voter suppression legislation that we are seeing around the country. So I think you have to look at this not in the context of Iowa 2, but through a broader lens, which is that that there are always going to be some, and unfortunately right now, predominantly Republican office holders, I should say, who are not, promoting or supporting voting rights and ballots and fair election results. From my standpoint, and I think for this, I now speak for the campaign, all we can do is make sure that every lawful vote is counted. The fact that there's going to be people who feel like that they're upset with the results of it can't really change you from doing what democracy requires, which is to obtain the consent of the governed through elections. And that means not only letting people vote, but making sure their votes count. And, I would love to say we're in a place where when that happens, everyone unites behind it. I continue to think that, fair-minded Democrats and Republicans, if they see that one candidate got more votes than the other, are going to want to do the right thing. But, I'm also living in the same world you are and realize that even in elections where, a candidate wins by 20,000 or 30,000 or 100,000 votes, there are still going to be people who on the other side who say, we don't believe it. I mean, I know, some of you cover Minnesota politics. The Republicans in Minnesota contested the election results of every Democratic House and member and Tina Smith after 2020. So, I think all we can all do is strive to do the best we can by voters, because it's ultimately their rights that we're here to protect. And I think if we do that in the end, people will come to understand that that's the right thing, even if in any given instance they are resistant. So that's a long answer, Laura, to your question, but it's something I think about a lot.
Great. Thanks, Laura. Mark, that is all the questions that I have. I don't know if you have anything that you'd like to close with.
No, just I really appreciate all of you continuing to follow this issue. It's really important. It's really important to get elections right, and to make sure that voters who, in the middle of a pandemic, went out and made sure that to get their absentee ballots and to cast them, that they're not then disenfranchised in the counting process. So thank you all for coming.
Great. I would echo that. Thank you all for joining us here today. The one thing that I will just add is that I have been recording this, the webinar. I forgot to record my part, so it's just Mark, but I will send a link around to that after.
Very, very convenient of you, Riley. Very convenient.
If you need my remarks, I can provide those to you upon request. So thanks again, everyone. We'll talk to you soon.